Yeah, welcome back, sir. So let us start the revision of the performance of a contract. है ना? First of all, what is the meaning of performance of a contract? सुनो बच्चों. Sir, performance means execution. Performance means execution of the duties by the parties to contract. You are doing your duty, I am doing my duty. It is performance. What is happening here right now in the class? Class is being performed. Your duty is to listen, you are listening. My duty is to teach, I am teaching. Here class is executed. That means class being performed. So performance means execution of duties by parties to contract. It is one of the method of discharge of a contract. You are performing your duty, I am performing my duty. The contract will be discharged. The class will be comes to an end. So performance is of two types basically. One is the attempted performance, other one is the actual performance. Actual performance means both the parties to contract performing their respective duties as per terms and conditions of the contract. I entered into contract with Ishwar for sale of the car for 30 lakhs. I am giving the car, I performed my duty. Ishwar also giving his 30 lakhs. Yes or no, sir? We both are performing our duties. It is said to be actual performance. Promiser offering his promise. I made a promise to give the car. I gave the car. Promise is accepting the offer of the promise. So Ishwar is taking the car, is giving the 30 lakhs also. Simply, both the parties to contract performing their respective duties as per terms and conditions of the contract. It is said to be the actual performance. What is the effect of the actual performance? So both the parties will be discharged. It is the valid method of performance and both the parties will be discharged from the respective duties. So offerer is doing what he is supposed to do, offeree is also doing what he is supposed to do. इसको बोलते हैं actual performance. Attempted performance, it is also said to be tender. Said to mean that means one of the parties attempting to perform his duty, but the other party is not performing his respective duty. My duty is to teach, I am teaching, but Ishwar is looking at the sweetie. Instead of looking at me. Your duty is to write the exam, I say duty is to make you pass. You are writing the exam, but I say is not making you pass. Attempting. In CA, the word attempt is very, very famous. So attempting to perform means one of the parties performing his duty, other party is not performing his duty. So my duty is to give the car, and Ishwar duty is to take the car and give the money. I am giving the car, but Ishwar is not taking the car. Ishwar is not giving the money. It is said to be attempted performance. So promiser offering to perform his promise. I made a promise to give delivery of the car. I am giving the car. However, promise is not accepting the offer. Yes or no? He is not accepting my car. He is not giving me money. So simply one of the party to contract attempting to perform his duty, however other party unable to perform his respective duty. It is said to be attempted performance. FX, it is not a valid method of performance because I am doing my duty but you are not doing your duty. Promiser is not responsible for non-performance. So I am giving the car, you are not taking my car, that is your fault. I am not responsible for non-performance. Promiser will not lose his rights. I have a right to file a case on you because it is your fault. So performance means execution of the duties. Two types: actual performance, attempted performance. Actual performance means both the parties doing the respective duties. Attempted performance means one party is performing his duty, other party is not performing. Attempted performance is of two types: tender of goods and services, tender of money. So tender of goods and services, my duty is to teach, I am teaching. Service, my duty is to give the car, I am giving the car. Good. But you are not taking the car, you are not listening to my class. Promiser offering goods and services, but promise is not accepting goods and services. So whether I should teach again? Not required. Can I file a case on you? Yes. Can I claim damages from you? Yes. So goods and services need not be offered again. Promiser is discharged from his duty. I have a duty to teach, I was teaching. My duty is complete. And promiser can sue promisee for not performing of his respective duty. And tender of money. Promiser offering to pay the money, but promise is not accepting the money. Actually, I have to give the money on the 1,125, 1 lakh rupees. I went to Ishwar's home along with 1 lakh rupees. I am offering the money, but Ishwar is not taking. Tender. Whether I am discharged from my payment? No, I have to offer again. So when I am offering 1,425, he is taking at that time after 3 months. Whether I have to pay interest for this period? Not liable to pay. So promiser is promisor is offering to pay the money, but promise is not accepting. Promise is not discharged from his obligation to pay. So promisor has to offer the money again, but he is not liable for the interest for this defaulting period. Done. Essentials of the tender beta. And beta. Clear na till now? So performance, actual performance, attempted performance, effects, and types of attempted performance, tender of goods and services, tender of money, and essentials of the valid tender. It must be unconditional. On 1st January, I said on 31st March, I will give the car. I am giving the car, you are not accepting the car. It is a tender. On 31st March, I said I will give the car if you take cycle also. It is not a valid tender because it must be unconditional. It must be made at a proper time. I said I will give the car on 31st March 3 o'clock. I am offering the car at 3 o'clock. You are not accepting. It's a tender. I have to give the car at 3 o'clock, but I am giving it 4 o'clock. It is not a valid tender. So it must be at the proper time, specified time, not specified, reasonable time. And promise I should give the reasonable proper place. So I said I will give the car at SR Nagar. I am giving the car at SR Nagar. You are not accepting. It is a tender. I have to give the car at SR Nagar, but I am giving the car at Kukadpalli. It is not a valid tender. So place is specified place, not specified business place. So promise should be given reasonable opportunity. I have to give the 10 bags of rice on 31st March. On 31st March, I am offering 10 bags of rice, but I should give a chance to offering for examination. If I am not giving the reasonable opportunity of verification, it is not a valid tender. And performance for the whole obligation, I have to give delivery of the 1000 kgs of the rice. I am offering 1000 kgs, not accepting tender. I am offering 800, not a valid tender. I am offering 1200, not a valid tender. But there can be minor deviation. I am supposed to offer 1000 kgs, but I am offering 999 only. 1 kg kam ho gaya because of loading unloading hota beta. Then still it is valid tender. It must be offered to proper person. Specified person, not specified only for the promisee, but not the promisee father, mother. It must be only for the specific person. Exact amount of legal tender. Legal tender means currency. I have to pay 12,500. I am paying 12,500, valid tender. If you are not accepting, I have to pay 12,500, but I am paying only 11,000, not valid. I am offering 13,000, still not valid. Done. Next, we did all these things better. Next concept is the who may demand the performance and who may perform the contract. So I made a small chart now. So performance, who may perform the contract, who may demand the performance. So I said I have to give the car to Ishwar. Who has to give the car? SG. To whom? Ishwar only. So who has to perform and who may demand the performance? So I said I will give you car on 31st March. Who has to give the car? So who may perform? Promisor. If promisor is deceased, promisor, legal representative. If skill is not involved, even third party. My employee can also give delivery of the car. And in case of joint promisors, for example, Inky, Pinky, Ponky, 3 promisors are there. If all are alive, all has to perform jointly. Death of any one of the joint promisor. Legal representative of the deceased promisor along with the other surviving promisors. Pinky, Ponky. In death of all the promisors, legal representatives of all the promisors jointly has to perform. Then next, who may demand the performance? Who may demand the performance? Generally, promisee may demand the performance. In case of death, his legal representative. Even third party can also demand the performance if it is ended for his benefit, stranger to consideration. In case of joint promises, if all are alive, all of them jointly can demand the performance. Death of one of the promisee, legal representative of the deceased promisee jointly with the other surviving promises can demand for the performance. Death of all the promises, legal representatives of all the promises jointly can demand for the performance. Next, we discussed about the rules regarding the joint promises. Very important. This was asked nearly 20 times in the exam beta. In this chapter, high category, main question, highest priority will be this concept only. So joint and several liability of the joint promisors. So if you make a joint promise, promisee can demand the performance from all of them or any one of them. All of them or any one of them. So A, B, C jointly made a promise to give 3000 rupees to D. So D can this 3000 rupees, one from 1000 rupees from A, one from B, one from C. Or can D demand everything from the A itself? Yes. Next, joint promises right to claim the contribution. Since everything is paid by A only, he can claim the contribution from the others. In this example, A only paid 3000 rupees to D. So A can demand 1000 rupees from B, 1000 rupees from C. Clear na beta? This examples only will come in the exam as it is. Next, joint promisers duty to share the loss from default in the contribution. For example, beta, A, B, C jointly made a promise to give 3000 rupees to D. C become insolvent. He can give only 500, but his duty 1000. So remaining 500 should be shared by A and B, 250, 250. But everything is paid by A only to D, 3000 rupees. So how much he can claim from the B? 1250. Then, for example, A, B, C jointly made a promise to give 3000 rupees to D. D become insolvent. He can contribute only 0. Nothing is there. So his contribution should be shared by A and B, 1500 and 1500. Everything is paid by A to D. So how much B can claim from A? 1500. Because this C's 1000 rupees should be shared by A and B, 1500 and 500 and 500. Then beta. And last one, effect of release of one of the joint promisor. As per Indian Contract Act, discharge of the one of the promisor will not discharge the others. So D said to Dhiren said to Charita, I love you. I will not ask you anything from you. But how much A and B has to contribute? 1500, 1500. And the party so discharged has to contribute to A and B, 500, 500. But as per English laws, discharge of C will discharge the A and B. Dhiren said to Charita, I love you. I am discharging you. Then Anjali Bhavita said, we too love you. Discharge us also. Then, so here, these are only important better from exam point of view. ये वाला exam में नया आता. I love you concept. Next, devolution of the rights and duties. Devolution means passing over from one person to another person. Next, rules figured in the time, place, manner of performance. Rules figured in the time, place, manner of performance. Time, again 3 rules are there beta. Place 1 rule and manner 1 rule. Where time for performance is not specified. Promiser agrees to perform without application by promise. I said to Nikhil on 31st March I will give car. What I will give? Car. But time is not specified. On 31st March when? Morning, afternoon, evening, 3 o'clock, 4 o'clock. Time is not specified. Then Nikhil is asking, so should I call you on that day? Not required. I only will call. So promiser agrees to perform without application by promise. You don't call me. Then who should call? Promiser has to call. So promiser has to perform within the reasonable time. 46. Next, time for performance specified. So on 31st March, afternoon 3 o'clock, I will give delivery of the car. Afternoon 3 o'clock. Time is specified. And promiser agrees to perform without application by promise. Promise is asking, so should I call you 1 hour before? Not required. I only will call exactly 3 o'clock. Then beta. So promiser has to perform only at the time specified time. Because time is specified. I said, you don't call me. I only will go. In my mobile, alarm is there. Remember the example? Good boys. So time is specified. 31st March afternoon 3 o'clock. But I said, Nikhil, I am a very busy person. I may forget about that. Do one thing. Call me 1 hour before. Remind me 1 hour before. So time is specified. 31st March afternoon 3 o'clock. Promiser not agrees to perform unless promise applies. So who has to apply? Promise has to apply. Next, place of performance. On 31st March I will give the car 3 o'clock. SR Kukudipalliya, Amirpeta. So place is not specified. Promiser agrees to perform without application by promise. Then promise is asking, sir, should I call you to fix the place? Don't call me. I only will call you. In my mobile alarm is there. Yes sir, no sir. So who should call? Promiser has to apply to promise to fix the place. 46, 47, 48, 49. Last one. Manner. We discussed about that proposal, wedding card. So promise prescribes the manner of the performance. Promiser has to perform only in the specified manner. Section 50. Not important from exam point of view. Next, whether time is essential for performance of a contract or not. है ना? Generally, if it is expressly agreed, time is essential for performance. So we gave coaching example. Coaching must be completed by October. So November, December you will prepare. January you will write the attempt. So I made a promise to your father. So time is essential. If there is any delay, if there is any delay if there is any delay, it will lead to injury to other parties. So time is essential. Example, doctor surgery. If you make a delay in surgery, no, but marja the patient. Next, nature and necessity of the contract requires like flowers, curd, milk, perishable goods. Time is essential. And assumptions by Indian Contract Act. In case of mercantile or non-mercantile transactions. In mercantile and business transactions, for delivery of the goods and services, generally time is deemed to be essential. For payment of the money, generally time is not deemed to be essential. For non-mercantile transactions, generally time is not deemed to be essential. If time is essential, no, contract will become voidable. Actually, I have to give the rice by morning 8 o'clock, but I'm supplying it at 12:45. There's a delay. So contract will become voidable at the option of the agreed party. Performance beyond the specified time is accepted, then he cannot claim damages. Performance not accepted, he can claim damages. And if it is not essential, no, contract is not voidable, and but agreed party can claim the damage if there is any. Clear? Then we discussed about the reciprocal promises. Reciprocal promises means promises forming consideration to each other. I made a promise to Nikhil to give the 3 months credit, and Nikhil made a promise to me to give the 3 months security for these 3 months. These two promises are said to be reciprocal promises. Promises forming consideration to each other. Lord Mansfield divided these into 3 types in the Jones versus Barclay: mutual and independent, mutual and dependent, mutual and concurrent. Mutual and independent, whether you perform your duty or not, I'll perform my duty. Faculty example. Mutual and dependent, if you perform your duty, then only I'll perform my duty. My performance is depending upon your performance. Mutual and concurrent, where both the parties has to perform at the same time, simultaneously. These are 6 types as per the contract act. These are the 6 types. First one, rules regarding the simultaneous performance, because both the parties has to perform at the same time. If you're not ready, no, I needn't perform my duty, because you're not ready, you should perform at the same time. Second one, order of performance, nothing but mutual and dependent. So we have to perform in the order specified. On 1st January, you have to give advance. On 31st March, I will give delivery of the car. If you're not giving advance on 1st January, you can't claim car on 31st March, because order is specified. First advance, next delivery. Next one, effect of preventing the performance. So you said to me, Srinath sir, you have to come to my home for whitewashing on 31st March, 10 o'clock morning. On 31st March, 10 o'clock, I came to your home for whitewashing, but door is locked. It becomes voidable at the option of the agreed party, because I am ready to perform, but you are preventing me from performance. Can I claim damages from you? Yes, agreed party can claim the damages from the party at default. Next, effect of performance in case of mutual and dependent. If the party supposed to perform first, unable to perform, then he can't demand performance from the other party. You have to give the advance on 1st April. Whether you give advance, no. How can you demand the car from me on 31st March? You can't. Done. Next, effect of promises to do legal and illegal things. So legal things are valid, illegal things are void. And effect of alternative promises, legal part and illegal part, separable, not separable. Separable, legal part valid, illegal part void. Not separable, everything will become illegal and void. Then we discuss about the assignment. Assignment means transfer of rights and duties to third party. So my class timings will be 2 to 4. I am unable to come to class. I am giving my class to maths faculty. Assigned my class to maths faculty. Assignment is of 2 types: by act of the parties, by operation of the law. By act of parties means both offerer and offeree talking to each other, and they transferring the rights and duties. That is by act of parties. Operation of the law, because of law only, act said that rights and duties transfer to other party. So it is said to be operation of law. By act of part is two types: assignment of rights, assignment of duties. So if rights and duties, skill is involved, cannot be assigned. Skill is not involved, can be assigned. Skill is involved like painting, marriage, singing. This is very, very important. Painting. So many questions are there. How many questions? In this chapter, A category will be A, B, C, jointly made a promise, joint promises. B category question will be skill involved. If skill is involved, cannot be assigned like singing, painting, marriage. And if skill is not involved, it can be assigned like taking the delivery, Amazon delivery. Next, by operation of the law, law itself said that rights and duties are transferred. It is two types. One is death, other one is the insolvency. In case of the death, rights and duties are automatically transferred to legal representative. In case of insolvency, rights and duties are automatically transferred to official receiver or the liquidator. Last concept beta in this chapter, appropriation of payments. This is also one of the important question in this chapter. 10 stars. How many stars beta? 10 stars. Appropriation of payments. Appropriation means application. Appropriation means application of payment to particular debt. See here, Apparao taken the several loans from the Ishwar. Apparao taken the several loans. On 4 for 14 taken 13,500 from Ishwar. 5 5 15 3,000 and 7,000, and 6 6 16 7 5 3 2 7 7 17 5,000 and 4,500. Dispute is there. So Ishwar is saying the worth of rice is 5,000, but Apparav is saying 4,500. It's called the disputed debt. And 8 8 18 24,000 and 9 9 19 15,000. Several loans taken by the Apparav from the Ishwar. Apparav have the habit of repaying also sometimes. For example, 2 to 20, he gave 6,000. He said, Ishwar sir, utilize this money for debt taken on the 8 8 18. 8 8 18. Debt to be discharged is indicated. We have to utilize this money only for the indicated debt. And 3 3 21, he is giving 7,000 rupees. Debt to be discharged is not indicated. It can be applied for any legal debt, including time barred debt, but not for the disputed debt. Neither party makes any appropriation. Then we have to follow the chronological order, FIFO, that is based on the time. Done. So with this, we have done with the revision of the performance of a contract. So in the next class, we'll do the scanner. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care.